We're talking about changing your divorce agreement later. So when it comes to things like child custody, yes, you can change them after the final decree of divorce. Those matters can be revisited after a final decree of divorce has been entered. When it comes to the issues of property division, the general rule is no. Whatever you've locked in on, whether that was a mediated settlement agreement, those are as binding as you can make them. Absent some sort of really dastardly fraud, you're locked in on that. And if there's a final trial and there's a property division decision on a final trial, you're pretty much locked into that one as well. So the big issue with regard to can you revisit the money after a final divorce decree? Can you revisit the property after a final divorce decree? Unless the other side has hidden assets, and seriously hidden assets. We're talking about offshore bank account, money tied up in a paramour's house, right? Something that was purchased with marital money for the benefit of another to be utilized by that spouse for their own personal gain after the divorce. Unless you can show something like that, whatever property division decisions are either going to be made by mediated settlement agreement or in a final hearing by the court, you're going to be locked in on those. You're not going to be able to revisit those. Now, the issues of child support and the issues of child custody, right? The parenting plan, what's in the best interest of the child, those generally can be revisited no quicker than 1 year, but generally within no more than 3 years from the entry of that original final order of divorce or final decree of divorce. And the reason for that is because courts don't want to hear about it just because your deal, your agreement, or your final order didn't work out after 11 months. So unless something substantial has changed, and you really do have to meet a high burden of a substantial change within that to bring one within or just after 12 months. And by substantial, a child has maybe you've uncovered a special need. Maybe they need special education. Maybe they need some sort of mentoring, coaching. Maybe they were injured. There's got to be some discovery of something substantial that would merit a change within that 12-month period. And that's a pretty tall order. It can be met sometimes, but rarely. But generally, what that means is whatever your final order says, it is like any other court case. It is a final order, and it is not to be revisited, with the exception of those things like future child custody, future support orders for the benefit of the child, and then occasionally, and in rarer occasions, when fraud is uncovered after the divorce decree is signed.